My name is Fred Pfister. I'm going to be presenting a Contracts 101 brought to you by the North San Diego County Realtors. And let's just give us a second here, maybe a minute for for anyone else joining, and welcome in. Well, good morning, everyone. I know everyone's time is valuable, and let's go ahead and get started. As you can see, this is a Contracts 101. So what this course is today is essentially a course about contracts for new realtors, and that's the intent. So as we start here, I'm going to give you my disclaimer because I am an attorney, and so I want to let you know that participating today, this isn't legal advice. I always encourage you to consult with your own attorney, your own office. Your office likely has an attorney. And if you want to get legal advice, make sure that you have an attorney-client relationship. This doesn't involve an attorney-client relationship here today. Well, here's my shameless plug for all of you of who I am. So some of you may know me, some of you may not, but I am the general counsel for North County. I have been since 2014, or I'm sorry, 2016, and I've been a partner at White and Bright is my law firm. We are based in Escondido. This is our 45th year of practice. I thank God I haven't been here that long, but I have been here about 15 years at this firm. And my practice, so that you know, it's a litigation and a transactional practice involving real estate. I consider myself a real estate attorney, and that's to the extent I'm going to be presenting today. Is what I'm trying to do in every presentation I do a number of these probably every other month. I'm doing either one for North County or for local offices. What I'm trying to do is keep you out of disputes. That is the goal. Selling real estate is highly litigious, as you will come to know if you don't know already. And one of the things that I try to do for my agents and broker clients is to keep them out of that. And so that's a big part of my practice. Uh, White and Bright specifically, these are a number of things we do. I'm not going to go over these in any detail here because I want to get on to the presentation here today that you all registered for. But if you are interested in that, you can take a look. I'll make sure these slides get out to anyone who wants them so they can see the full scope of what we do. Okay, well, thank you guys. As I was alluding to, this is a Contracts 101 course. So we're going to cover a number of topics that really have to do with what are some of the things you have to do with respect to with contracts. What do you need to know? Um, I'm gonna go over some contract concerns, things that I see that are problems that a lot of new agents and even experienced. I'll have people who have been doing this for 40 years, and sometimes they still make the same they encounter the same problems. So we talk about writing a contract correctly, top contract risks, and then a list of some final tips for agents and brokers. But overall, the goal today and my focus is reducing risk. Yeah, learning how to use the contracts, learning how to fill them out is what you're trying to do is you're trying to avoid what I would call preventable disputes. And sometimes these things are minor. It could be as simple as, the fridge that comes with the property. You might consider that very minor. They also could be multi-million dollar disputes. And it and so what we're focused here on today is how to avoid that and better understand the CAR forms that you're going to come to know and love and improve your transaction management. So let's jump right in. So I'm starting with something very basic because I understand that, some people they think of the contract as just a form that they fill out. But I start with this because the basic definition of a contract is what it says here. It's a legally enforceable agreement between two or more parties that creates obligations that each party is required to perform. And there really are four elements in any contract, and a contract can be really any type of written agreement. It actually could be an oral agreement too. But for our purposes, we're dealing in real estate, so we're dealing with written contracts. There must be an offer where one party proposes terms. There must be acceptance where the other party accepts those exact terms. And a contract also requires consideration. Something of value must be exchanged. I sometimes get situations where people, they're giving something for free, but there's nothing in exchange for it. And that was what we would call a lack of consideration. If you're just giving something for free and there's no expectation of anything of value exchanged, that can be that contract can fail as not legally enforceable. And there also has to be mutual consent, that the parties have to understand and agree to the same material terms. That's essentially why we have these written CAR forms, is that, and that both parties sign because there's mutual consent on these forms. So here's kind of a practical takeaway. So in your real estate transactions, the contract that you're going to know and love is the residential purchase agreement called the RPA. And this contract, from a basic level, and we'll get into more detail, is it identifies who the parties are. It identifies what property is being sold. That's the easy part, right? The one that people always talk about is, oh, the purchase price. But here's what I think, those are that's the easy part, right? Anyone can say this property is 1.2 million. Here's what the address is, and here are the parties. And by the way, I see people getting parties wrong sometimes. But I think the key thing that you really need to know in the residential purchase agreement and in your practice is is getting really familiar with the timing of the transaction. There is a lot of dates. There are a lot of timing considerations, and being familiar with that, I think, is extremely important. The next item really I think is the most important, is each party's obligations in the transaction. That's what, if the RPA was just the purchase price and the property being sold in the parties, it wouldn't be as many pages as it is, because you have that, once you fill in the blanks, or once you add what I would call the material terms, all of those terms are modified by I would call the guts of the contract, and that's where the real that's where the really important part of you being an agent comes into play, because you need to understand the terms. It's not it's not just being able to fill in the blanks, because each blank then refers to a paragraph that explains what's going on. And I'll give you an example. For instance, if you check your client may be saying, you know I don't want a loan contingency, right? I want to make my offer more attractive. Let's check the box on no loan contingency. And that's in 3L1 of the contract. But that doesn't mean the buyer, you should know that doesn't necessarily mean that the buyer is not getting a loan. That simply means that it's not a contingency for the transaction. So if you go later, if you're representing a buyer and you check that box, you have to be able to explain what that means. That it doesn't mean that there's no loan, or that they're not going to source a loan. They're not going to spend a lot of time getting a loan. Most people do get loans in residential transactions. What it means is that it doesn't necessarily, it's not grounds for them to terminate later. So when that loan fails for whatever reason, that's you don't want to use that as the grounds to try to terminate the transaction. So I think my takeaway from this is that you have to be familiar with the actual terms of the agreement, the detailed terms, not just well, I'll check the box for no loan contingency. The The other practical takeaway is what happens if something goes wrong? The residential purchase agreement and a number of other forms are, explicit if something goes wrong or if there's or if, what are the remedies? And each party has different remedies, and it really matters. And so I'm going to talk a little bit about that when we get into it. I put up this quote: "If it's not in writing, it may not be enforceable." This is this is what this is what should be your motto as you transact real estate. That if something is not in writing, people will swear that conversation never happened. They never understood it the same way you did. You could have 100 conversations with someone, and if it's not in writing, it's not going to be it. You're going to get into you'll be in litigation, and you're going to swear that this happened. Someone else is going to swear that it didn't happen, and so that's why the real estate contract should be your Bible or um, you know, you're essentially what you always should put stuff in writing if you want it actually to be enforced. And so what I say is it's not a formality, it's not simply standard forms, it's what the terms of the deal are. So as we get into this, here are the key contracts that I think are the most important for you to know. And you should be intimately familiar with these forms. These are the major forms that are in any transaction. I would certainly work on the RPA. I've talked a little bit about it already. You should be very familiar with that form. I'm sure that you've studied it. Study it more, right? Because it's constantly updated. I think but just about every year they're making an update to that form. So I'd be very familiar with that. The one that I see is often a problem is this counteroffer form, and I'll explain why in a little bit. But that's another one because it to me, sometimes people just accept an RPA, but often there's counteroffers, and I'm going to talk to you a little bit about how counteroffers are the area where I see a number of disputes because people are negotiating legal terms without they're flying by the seat of their pants sometimes without a standard form in front of them, and so they put in very vague terms into a counteroffer. The next one is the request for repairs. So this is the RRRR form. Be very familiar with this. I see a number of disputes with this form. I'll explain why in a little bit. But this is another form because I'd say most transactions have some type of request for repairs in residential transactions. Sometimes it's a function of the property, it's a function of negotiating that request for repairs, but being very clear with that form is, I think, critical for on the buy side and the sell side. The next one that I think you should be very familiar with is the AVID. That is your disclosure form. And I have a presentation that I often do regarding the AVID, how to fill it out. It's become a lot more detailed than it used to be. People have this misunderstanding that it's just a visual. It's not. If you take a look at that form, it talks also about material facts that you know of, and you could have information that isn't just visual. And so I caution you that you should be very familiar with that form, take a class on that form, and make sure that you're filling out those correctly because you can and will be challenged on it at some point in your career. The SBQ and TDS, the reason why I bring these up, and because you're probably looking at those of you who are, have been doing some transactions, you're very familiar that, wait, I don't fill those out. Those are filled out by the seller. The seller fills out those forms. That's their disclosure. Well, I bring this up because you have a disclosure obligation that is similar to the seller to the extent that you have knowledge. And 90% of the disputes that we see are non-disclosure of material facts. And where do they come from? They come from the SBQ and the TDS. And the reason why they come from those forms is that's the opportunity for people to disclose what they know about their own property. And they often have questions for their agents about should I disclose this or should I disclose that? And oftentimes what they'll accuse their own seller or their own agent of is that the agent told me not to disclose that. The agent told me I didn't have to do that. Now, whether that's true or not, again, it's their version of events. And so being very familiar with your disclosure obligations, with the buyer, or I'm sorry, with the seller's disclosure obligations is very important. And also on the buy side, when you get that SBQ, you get that TDS, being familiar with, okay, what does this actually say? What do we need to follow up on? Um, Extremely important document if you want to avoid litigation and you want to be a better agent. Forget about litigation for a second. If you want to be a better agent and really add value to your client, you need to know your disclosure obligations. I also put in here the contingency removal form because that's I would say the most important part of a transaction is when we call it going hard on the money, right? You put on your earnest money your earnest money, and when you do the contingency removal, that's when you're really in the transaction, right? That's when you're moving towards closing and the money has gone hard, meaning it may or may not be non-refundable depending on the circumstances. But knowing how to use that form, I think is very important. I would also potentially add to this, the residential listing agreement, the buyer representation form. Those are more on your side, but I would bring those up because if you have to negotiate those forms. It's not like it was, 15 years ago or even maybe even 5 years ago where people just signed a residential listing form or they didn't even sign a broker form most of the or a buyer form um, until fairly recently. You could, but it was rare. Yeah, and so part of what I would think is one of your negotiating skills is negotiating for yourself. I would think on a buyer side, how well can this person negotiate for themselves? That's going to be a flavor of how they negotiate for me in this transaction. So become very familiar with those forms. They're particularly the buyer form is constantly changing as we move forward in the last couple of years, and so be very familiar with those forms as well. So giving you a flavor of the RPA, certainly this is the form. If you know one form, this is the form you have to know. And it talks about, I've already talked about the kind of the purchase price. It also talks about deposits, timelines, contingencies. Will there be, what's possession, the default rights, if one side or the other defaults. There's a mediation arbitration component. That's the type of thing that if your client has questions on, don't guess. It's the type of thing that you can always refer to counsel on something like that. Encourage them to read it. There are helpful forms from CAR that you can give to your client to explain what those terms mean. But what I wouldn't do is go out on a limb and be like, oh yeah, if this happens, you're going to be in arbitration because it's not necessarily true they will be. There's ways to get out of that. There's ways to get into that. That's really a legal question. And so it's not making those representations. And of course, the RPA has the commission entitlement, right? You're negotiating part of your commission because it works with the other forms. And that's a key point, I think, is that there's so many forms and a lot of them work together. And so something like your commission entitlement, it's going to be on a separate form, but it's also part of the RPA, right? The RPA is going to reference how you're going to get your commission on that separate form. So knowing how the forms work together is really important on something like this. Um, Let me explain this example here. Um, so one of the key things that I see is that people want to do transactions quickly, right? There's a lot going on. People get it. The offer is that big time, right? You're submitting offers. We're looking at all these houses. We submit an offer, and people try to do it really quickly, right? They do it really quickly because they want to get that home, right? And so that sometimes I don't want to call it cut corners, but they're sometimes so quick that they haven't really explained the form to their client before they hit send and send it off, and then they think that they have this, but then they call the other agent and say, yeah, this is the deal, and if it's not in writing, your verbal your verbal understanding isn't going to fly. And so the scenario that I've seen numerous times and I've had agents talk to me about is, this is a very basic one, right? Was the washer and dryer included? The buyer thought it was, but guess what? It wasn't checked that it was going to be included. The seller believed, they read the contract, that it was excluded, that they were going to keep that washer and dryer. Well, what's the result? It's a potential dispute. And you might think, well, this isn't a huge dispute, but I've had, a dozen agents tell me over the years that they ended up paying because of their mistake. They ended up paying for a new washer dryer or a new fridge or some other thing where their buyer believed one thing, the seller believed another one. It got into a dispute, and there's the agent with egg on their face. And part of it is, I'm not blaming the agent. It could be miscommunication, but that's why I think it's so important at that early stage, while you're doing that offer, while you're going through the form, is to walk your client through the form. Make sure that they approve it. Make sure that they understand what is included, what is excluded. What are the other terms? Are we doing that loan contingency? What other, do we need more time for that loan contingency, right? Maybe 17 days isn't sufficient. Um, Maybe we're going to have an insurance issue. Negotiating those terms up front is a heck of a lot easier than getting involved in the transaction and trying to change things later. Then I'm not saying that can't be done, and I'm not saying that's not appropriate to do, but having the upfront expectation is your baseline. So let me talk to you about some of the common contract concerns that I see, um, because I think this kind of is important for when you're filling out this contract. And this is from what I see as, this is I'm using attorneys in general, but I'm also using my experience in my office. My office, we have 8 attorneys here. We all practice residential real estate. What do I see on the files that come to my office? Because often the files that come to my office are the ones in dispute. Let's be honest, right? If you do a perfect transaction, you fill out the forms correctly, you have a happy client, you have a happy seller on the other side or buyer on the other side, you're probably not going to end up with these types of issues. Well, here's the issues that I see when I see disputes. Blank spaces. This is very common. People just don't fill out the form. There's some required, if you're using zip forms, for instance, there's some required blank spaces that they require you to fill out, for instance, like the address or something like that. But there's a lot of things you can easily miss. And what I see is people not effectively filling out the form. I'll use the example of an AVID. I mean, I've seen a number of the agent visual disclosures where it's almost like a perfect house, right? They just kind of glance through it. They did it really quickly. At least I think they did it really quickly because I see like one issue, and I'll tell you, that just doesn't typically fly. So making sure that you're understanding that blank spaces are either a negotiating term or something you have to fill out. A lot of the way that RPA is set up is it's a default or blank, right? And making sure that you have that discussion and make sure that you review what that blank is because you may want to alter it. Incorrect dates. Where I would bring this up is it's it's essentially dates that are unrealistic. I'll go back to that loan issue again, not to belabor that point, but if you think that the loan is going to be challenging, making sure that you have sufficient time for if that's going to be your major contingency, and don't even if you push that one out, make sure that your other ones aren't inconsistent, right? So, for instance, let's say you have all your, let's say you think you might have a problem with the loan, and you say, well, we're going to need 45 days for the loan, right? I'm using a hypothetical here. We're going to need 45 days for the loan, but you leave all your other contingencies for a shorter period of time. Well, if you get down the path, let's say all your other contingencies expire within 30 days. Now you're at the 35th day, and your client comes to you and says, "Well, it looks like I'm getting the loan, but I don't like this other issue that has come up." Well, you might have a problem because you've already released your other contingencies. Um, and your only contingency might be that loan that's still outstanding. So the reason why I bring this up is I like in to see, at least when I'm doing transactions, I like to try to key all the contingency dates to be around the same date so that we preserve as many as possible. But incorrect dates is a problem I see. I'll also give you another example here is is when people start coloring outside the lines. And this can be incorrect dates or it can be inconsistent terms, or the reason why I highlighted here poorly written addenda or counteroffers, where I see people, and I call it coloring outside the lines because people start writing custom forms because something has come up, and they think, well, I'll write this. The client's relying upon me. I'm not going to seek legal counsel. I'm going to write it. Well, the example I would give is recently had a case where there was a lease. It was a long escrow, and they put a lease in place so that the buyer could actually occupy the property. And I don't recommend that, but the buyer was occupying the property. Well, the lease had a custom addenda, and the purchase agreement had a custom addenda about when the transaction would actually, when the buyer actually had to close. Um, and under what conditions. Well, guess what? They were inconsistent. They had different dates and they had different terms. Which one controls? Well, your buyer may say one thing, you may say another, the seller might say a third thing. And guess where it ended up? It ended up in a trial, not just litigation, it ended up in a trial over who was right. And that could have been avoided from the beginning with consistency, or legal counsel drafting it, or just making sure that they weren't entering into a transaction that kind of went off the rails. So it, it I bring that up because I'll kind of hit that point as we go here that when you start coloring outside the lines, you end up risking your transaction, and that's what I would call a poorly written contract. Another one is certainly repair requests that are not specific. I have a slide that I'll show you on this, but I see a lot of disputes over repair requests. It's not just in the transaction, it's also after it closes because people say, well, we'll fix that, right? We'll fix that issue. And okay, under what terms? Are you going to use a licensed contractor or an unlicensed contractor? What's the standard? When will it be done? There's often a lot of disputes about that. Verbal side agreements, I kind of already touched on that, but having a side agreement that's verbal, good luck with it. I would strongly encourage you not to make verbal side agreements, that everything should be in writing in a real estate transaction. Missed deadlines. This really refers to an agent not keeping up with the deadlines that they drafted. Too often, what I'm seeing with the matters that come across my desk is that an agent has put the property into escrow, they've passed it off to the TC, and they've moved on to the next deal, right? And think that, well, the transaction coordinator will make sure that these deadlines are hit and that the documents come in. And I would encourage you to get a great TC, but the TC is not the one who's in, you know, they're not the one in section 2 of the RPA. They're not there. It's not their license on the line. They're not the responsible party with the fiduciary duty. And so missing deadlines, I think, is kind of a critical issue. And then, of course, missing addenda. Um, and that's not using the form that or providing it very late. I mean, I've seen transactions where the AVID was provided after the closing. Uh, that's not in compliance. I've seen people they're not familiar with the form where I say, well, hey, did you use this specific form, and they just weren't aware of the form that it even existed. And so making sure that you're using the correct form. And this is part of your experience, this is part of education. And I would say it's reliance upon your broker. One of the key things that you have as a new agent is you have a broker who you work under. One of the purposes of that broker isn't just to help you with marketing, it's also to help you with the forms and helping with your compliance in a transaction. And I encourage you to do this. I encourage when I speak to brokers, I do broker presentations. I tell them have an open door policy and help your agents make sure that they are the one who knows the contract, and encourage your agents to ask you questions throughout the transaction so that so they're not just guessing, because that's where I see a lot of issues is when people guess and don't make it a situation where they're afraid to come ask you or they're embarrassed. Um, I'll go through this one fairly quick here because I think I've hit on a couple of these. The thing I'm bringing up here is contingencies are very time sensitive. Um, and what people don't understand in these contracts are, they require active release of the contingencies. And so what people often come to me and say, well, we're out of contract. They use that term. Well, we missed the deadline, and maybe we have a notice to perform, maybe we don't, but we're beyond our time frame. I would be very strict on these time frames, whether no matter which side you're on. Being strict on the timelines, making sure that you monitor them, um, and create I call it an abstract, but you may have a term that's within your office of essentially the calendar of once you enter into that contract, making sure that you've calendared all the dates, all the critical dates, particularly when they're non-standard, right? If you're just using all the defaults, that's one thing, but oftentimes you're not. And trying to remember that while you're working on 2 or 3 other transactions and you're dealing with family and you're dealing with all the other things going on in your life is very difficult. I'll admit it. And so making sure that you are organized on deadlines is critical for your compliance with the contract, because there are so many deadlines, right? There are so many things that you need to be aware of. Here's my example of the missed loan contingency. Let's say you have a 17-day loan contingency, day 18 arrives, you haven't released it, there's no extension. Well, the seller may be coming to you with a notice to perform, and the buyer just assumes, well, it's the lender's fault. It's not my fault. I'd love to release the loan contingency, but the lender's still working on it. Well, the seller, as an agent, you need to be explaining to your client, this is what we agreed to. This notice perform, if we don't release that contingency or get some type of an extension, they're going to have the opportunity to cancel the deal. And so the reason why I'm bringing it up is don't make it a surprise to your client. Your client needs to be informed throughout. That's really where you add the value is, a lot of buyers, a lot of sellers, they're very inexperienced. They buy or sell a home once or twice in their lives, right? And they don't know these forms. These forms just changed 2 years ago, right? The last time they might have sold their home was 15 years ago, right? And so explaining to them, being their resource on something like a loan contingency or inspection contingency or appraisal contingency, whatever it is really where you add the value. And And here's the reality is if if you're doing this, the buyer may be exposed to termination or a default risk. Um, so so again, the lesson is track deadlines aggressively. So writing a contract correctly. I bring this up. The goal is not merely to get the deal signed, right? It is really to get the terms that are important to you, that are important to your client. Um, because again, this is the clear roadmap for the transaction, the expectations, it reduces disputes, because at its core, a real estate contract is it's not only enforceable by attorneys like me, but it's also the biggest transaction in people's lives. I know I kind of just hit that a second ago, but it might be the most important transaction that they ever make, not only on their emotional side, but their financial side. And so the goal is to have that upfront conversation to make sure that the terms that they believe they are signing are actually in the agreement. And the way I typically do that is not just to send them a DocuSign, but to actually walk them through the contract to make sure that it meets their expectations. Because everyone loves DocuSign because it's very efficient. Heck, we use it here at the firm, but at the same time, people are looking at a 17-page contract with all the addendum. It could be 50 pages of documents. They're looking at it on their phone, right? And are they really looking at the detail? And so having that conversation, I think, is critically important. And this is my other, um, uh, you know, thought on writing a contract correctly is that every contract should be written as if a judge may read it later, or that a stranger must understand it. And the reason why I bring these up is you will be judged on that. If your contract is unclear or has inconsistencies or it's missing terms, it's and it goes to litigation, you know who's gonna interpret that? The judge is going to interpret that, right? And having a stranger understand it is the attorneys. Will the attorneys be able to understand what you wrote? Because they're going to be the ones arguing whether you were right or wrong. So every contract should be written that way, that as if a judge will read it later. And there's also the point that, the parties will disagree. Every dispute is because there's a disagreement about what was intended, right? One party says this, one party says that. And so that's why, CAR has gone to such lengths to create these forms. Um, because what they're trying to do is trying to get standard language that everyone understands, right? And so that's when I was saying before, when you deviate from the script, you're what you're doing is you're going away from something that everyone might agree to, and you're coloring outside the lines, right? So my principles here that I think you should always look for is be clear, be specific, right? The more specific, the better, and be consistent. Certainly document everything. And I'll talk about that just in a second, but it's not just documenting in the forms. It's also documenting in notes, in confirming emails. It's making sure that, documenting conversations. Avoid assumptions about what might happen, or what that what a disclosure might entail. Um, and of course, review all related documents together. The documents all work together on the CAR forms. They're not simply standalone documents. You might think, well, this is just a standalone disclosure, but it's like a natural hazard disclosure, right? You might think, oh, that's just a standalone disclosure. Well, it's actually incorporated into the RPA, right? It's a document that has to be provided at a certain time, by a certain company, perhaps if that's filled in, and it's something that the buyer has to is required to review, whether they reviewed it or not. It says that they will. So all these documents are related and they work together. I think that's another key principle. So I said I would jump to something like a counter offer, because I see a lot of disputes. I kind of highlighted that earlier. A counter offer is where I see a lot of disputes, and I think I know why. Is that you get into the transaction. Here's my offer. The other side then counter offers it. If it's just the price, right, or which escrow officer we're using, we're not getting into the issues, right? We're probably not going to have a dispute. We're probably all going to agree that instead of 1.2 million, it's 1.3 or something like that. Where I see that the problems and I think the effective contract 101 on counteroffers is when people start going and making vague representations. And I'll give you an example here. I've seen this direct language. Seller to provide credit for repairs. That was literally a term in the counteroffer that a part that and both parties agreed to it, right? Well, you can see where the dispute would come up, right? Maybe you're intuitively thinking, well, how much is the credit, right? A credit towards what? What are we talking about? Are we talking about $100,000? Are we talking about $2,000? So is the credit capped? Does it replace, does this replace the repair form? Do we not have to provide the RRRR form? Is it just a given that they're going to do these repairs and who's going to pay for them? Um, and so you can see the result is that the buyer and seller later disagreed about the amount and purpose of the credit. Uh, and it was because that was such a vague comment, right? The seller probably told the agent, "Oh, don't worry, we'll provide a credit for repairs." If they keep the price the same, instead of let's increase the price, but we'll do a credit for repairs. And so the agent literally wrote, "Seller to provide credit for repairs." Well, that's a problem. Um, Here's another one. Closing may be extended if lender needs additional time. Again, a direct quote. Well, again, how long is the extension? Who decides if more time is needed, right? Is it the lender? The lender's not a party to the agreement, right? The lender's a third party who's may or may not be giving the buyer a loan, right? Is written notice required to get that additional time? Does the seller have to agree? What if the buyer came and said, "I want 4 more months to get uh, my extension on my loan"? Does the buyer need proof, right? Does the buyer can just say, "I want 4 more months," right? Or do they have to show that there's a particular reason? Four may be an exaggeration, but what if it's 30 days, right? That seller may have not agreed to that. So what you can see as the result is the parties dispute whether escrow was properly extended or whether one side defaulted. And guess what? They end up in mediation or arbitration or litigation over this term, right? And so again, this is something where agent was trying to be helpful. Closing will be extended. They probably heard that from their seller. Yeah, that's fine. We'll extend the time, but that's not a clear term, right? Um, there's much better ways to put that into a transaction. Let me talk about disclosure liability for a second. I'll move to something a little bit different. So disclosure issues can create major litigation risk. I'd say that the big disputes in real estate transactions are over disclosures. These are just a sample of the ones. I teach an entire class several times a year over disclosure liability. And this really goes to that SBQ, that TDS, the AVID, those types of forms. And I encourage you all to, take my class, take other classes, get very familiar with your disclosure obligations because this is part of your contract work. Part of your contract work is not just the RPA; it's understanding disclosures because that's where the claims are going to be. I would characterize there's two main categories of disputes in real estate transactions. One is what I would call the escrow or transaction disputes when there's a problem in a transaction, oftentimes because there's unclear wording like that, buyer to or the extension if the lender needs it, right? That's what I would call disputes in the transaction. But the big ones, actually, the second category is non-disclosure claims post closing. And so understanding the disclosure issues, again, encourage you to take that class. Here's kind of an example of something where someone, calls it a minor leak. And this is part of your contract terminology, right? You put in, oh, there was a minor leak, and the seller's position was there was just one small, just a small leak once, right? And you put that in your AVID, perhaps. It was just minor leak in kitchen or something like that. Well, maybe the actual history is that there was a prior insurance claim. There were multiple repairs of this thing. It's a reoccurring issue. I'm making that up for the purposes of here, but what happens? You close escrow, you think it's all great. Oh, I disclosed it was a minor leak. And the buyer discovers that there's major water intrusion after the close of escrow to $200,000 kitchen remodel, right? And maybe it is covered by insurance, maybe it's not covered by insurance, but who do they go after? Well, they go after they go after the seller, and they go after the seller's agent because the seller's agent wrote minor leak, and they didn't disclose this, and they got fraud claims, failure to disclose. The broker now is involved. The broker gets sued, and what's the end result? Really expensive litigation. And so knowing how to fill out your AVID and advising your client on what what to do and not to do on their disclosures, I think is a critical part of understanding contracts because it's the area where I see the most major litigation is it's always non-disclosure of material facts. So take a class on that, really understand that, what to do and what not to do. I bring up this document, the notice perform. This is another contract that should be part of your toolkit. A lot of people, or well, I shouldn't say a lot of people. I see a number of agents who are very reluctant to provide the notice to perform. And I think hopefully you guys know how to use the notice to perform. Maybe I'm going off the 101 here and going to 201 on this. But the notice to perform is essentially when someone fails to do something that they're required to do. Oftentimes it's release contingency or it's to provide certain information. Maybe the seller is supposed to give documents, they don't give documents. And these notice perform are from the buy side and the sell side, where you can send a notice to the other side and say, hey, you missed this deadline or you didn't do this thing. And I want you to perform within this period of time. And I think people are reluctant to do it because to some extent, they're embarrassed, right? Or they still want the deal and they don't want to upset the other agent. They want to get along with the other agent. And they don't want to be a jerk, right? They don't want to be like, oh, you missed the deadline by an hour. Here's my notice perform. I take the opposite approach. I tell agents, effectively use the notice to perform. Be very familiar with how to use it and when to use it, and use it aggressively. And it doesn't mean you have to be a jerk about it. What I tell people is they miss a deadline, send that notice to perform immediately, and then give them a call and say, hey, we still want the deal. I don't want to breach my fiduciary duty to my client. I want to make sure that um, I'm protecting them. And, you have 2 days to perform on this or whatever is negotiating the contract. You have the time to perform. We're just trying to keep this transaction on schedule. Most of the time, I think that goes over really well. And it also protects your client because what I've seen in a number of transactions, and I'll just put the rest of the slide up, is people don't, and it's a week later, and then they call me and say, yeah, we're out of contract. They missed this deadline, and we still want to move forward. And I asked, did you provide notice to perform? Oh no, I didn't want to do that. Well, guess what? Then their client criticizes them because they're out of their deadlines are extended and they have other things going on, and then they still might have to enforce their contract, and so they've just put themselves behind the eight ball. So, here's the common mistakes is that deadlines automatically extend. They don't, or they usually don't, I should say. And so it's extremely important to know how to use these notice perform forms. Let's talk about the contract risks. I'm cognizant of the time here. We might go a little bit over. If we do, that's I encourage you to stay and if you can. And I should have mentioned this at the beginning, but I'll certainly open it to some questions at the end, and give you my contact information if you want to follow up. Um, but here's some of the contract risks. I've hit several of these already, so I'll just throw them up here. But I want to hit the ones that I haven't hit. Certainly, one of them is the giving legal advice. This is a no-no. This is something that you shouldn't be doing um, as a client, as a real estate agent, is giving legal advice. I've seen numerous cases where people have, they've told their client this is what's going to happen, or this is what the import of something is. And I'll give a slide in just a second on this. But giving legal advice is one that you should not be doing. You should not be practicing unless you are an attorney. You should not be giving legal advice on the transaction, which is somewhat counterintuitive to a lot of people because they think, well, the entire contract is legal advice, right? Or the entire contract, Fred, didn't you just say that these all are enforceable legal terms? Well, to some extent they are. But the way I look at it is you're telling them what the form says. You're not telling them what might happen in the future if there is, legal action. Um, so addition verbal agreements, we kind of hit on that. And here's kind of the most contract, here's the rest of my slide is I think most contract disputes are preventable. And they come from make assumptions, poor communication. A lot of times the transactions I see that have problems are because there wasn't communication about what's actually in the forms. There wasn't a lot of interaction between the client and the agent. And so that's something I would make sure that as part of your practice is that constant communication is preferred. Um, Contract risks, this is, again, I think I already hit this, so I'm going to skip this to some extent that, it's one integrated agreement made up of multiple documents. But I'll hit this one. This issue is that when one piece changes, the other documents might need to change too. This is where you have to take a holistic approach because if you end up, halfway through the transaction and you negotiate an extension that's in writing, by the way, negotiate that extension in writing. That might change some of your other terms and other documents. And so taking a holistic approach is really important. Making sure that you move all your other deadlines and really look at that. Um, so the poor drafting issues, I'm going to hit what I would call the confirmed details in writing section. This is what I would think is the issue that a number of people miss is real estate transactions are fluid. You might have a lot of text messages. You might have a lot of conversations with your client. And one of the things that I see, it could be new agents, it could be experienced agents, is they're not confirming the details of their conversations, important conversations in writing after the fact. And they're making verbal deals. And this is, again, asking yourself, if a stranger reviewed this file, would the agreement be clear? Would all obligations be defined? Are the timelines specific? Is performance measurable? Here's another example of the repair request, right? I talked about it in the context of a counteroffer, but this is also applicable to that repair request. Remember, I said that was a really important document that you should be very familiar with. Well, the reason is because there's often a lot of disputes over repairs, and these are things that I've seen people write in. Well, we're going to fix the HVAC. We're going to repair the roof. We're going to correct the plumbing. Well, to what standard, right? By whom? With permits? When is it going to happen? Can it happen? Can someone repair a roof in the next 2 weeks of the transaction? Maybe, maybe not. Is it better just to get a closing credit, right? And if you're negotiating a closing credit, because that's typically what I prefer, is say, well, instead of doing this thing that may or may not be to the satisfaction of the buyer, why don't you just give them money instead and they can do it themselves? Well, great. You might think, well, that's the preferred route. Well, are you negotiating the right amount, right? If they're agreeing to repair the roof and you only take a $10,000 credit, can you actually repair the roof for $10,000? Do you have a bid? And I've seen people criticized for that. So it's very critical that when you're working on the repair request that you be specific. Because here's a drafting example. Seller to repair roof leak, right? That's weak. Here's a much better format. Seller, prior to the close of escrow, repair the roof leak identified in buyer's inspection report dated May 10th, 2026. Now you're being specific as to what that repair is. And then you're saying using a licensing roofing contractor, so not Fred the handyman, but Fred the licensed contractor who is going to stand behind it and provide paid invoices and transferable warranties prior to closing, right? Because their warranty may be with the other person, and there may be a contract that seller signs that says no transferable warranty. Well, the buyer just bought a property they might have used a licensed person, they might have this repair done, but guess what? Now they don't have a warranty. And when it fails in a year and they try to go back, they come back and say, why didn't we get a warranty? Why didn't that transfer? So this is just an example of a better version versus a weak version. Don't be weak, be specific. Identify, and if you have questions on that, that's the type of thing. Go to your broker, go to the attorney, go to your broker's attorney. Let them draft it, right? Be specific on something like this because it can be you might get away with it a couple times, you might get away with it your entire career, but when you don't, you won't. When it comes back, you're going to wish you wrote the better version or something similar to this. Um, I hit this issue. Agents are not lawyers, and I don't mean this negatively. But what I'm saying is you can be criticized for this based on your fiduciary duty, and I'll give you an example. But agents shouldn't be interpreting statutes. They shouldn't be giving legal opinions. They shouldn't be drafting complex custom clauses beyond their competency. And again, I don't mean that negatively. I just mean that, for instance, that example of when will the closing happen versus the lease versus the extension or the amendment to a contract. That should have been reviewed by counsel. Don't advise on litigation strategy. That's practicing law without a license, and it's also potentially exposing you to a breach of your fiduciary duty. The safer approach is say, I recommend you consult with legal counsel, and put it on the buyer or put it on the seller to get their own advice on something like that. The same way you wouldn't opine about the roof, right? Unless you're a roofing contractor, you're not going to opine about that. And so why are you opining about litigation strategy? Here's an example from an easement. The buyer asks you, can the neighbor legally use this driveway? And the agent just answers, no, that easement is invalid. Well, that's legal advice. Are they qualified to give that opinion? That would typically take investigation, and even when the attorney reviewed it, they might say, well, that ultimately that might be up to a judge. Here's what I see, but ultimately that could be the source of litigation. So an agent shouldn't be opining about something like that. That's not part of your contract duties. And the problem is that the agent made a legal conclusion. And you might think, well, this isn't necessarily part of the contract. I think this absolutely is part of your contract duties. Is making sure that you're saying something to the effect of, well, that's a legal issue that should be reviewed by the attorney or in the title company. because that's where that should go. You shouldn't be opining about something like that. I'll hit this one quickly. I know we're hitting at the end of our time here. Um, so verbal agreements are dangerous. I think they really are because people talk, agents talk about credits, possession, repairs, included items, but nothing gets documented. And everyone remembers conversations differently. And so I can't say this enough to people. I do this in my other classes, is make sure you document things in writing. If it's not in writing, it didn't happen. Um, you know, here's an example is agent text, don't worry, seller will fix that, right? Or seller would have disclosed if there was a problem, right? Well, the seller might not have disclosed if there was a problem, right? In fact, a lot of sellers hide information because they think it drops the value of their property. So when you have an inkling of something that's important to your client, you shouldn't be saying in a text message the seller would have disclosed if there was a problem. The seller might have actually hid it. And so that's an example of something that, well, if it's important to your client, making sure, first of all, you're documenting it effectively to them, but then you're also using the forms correctly to ask for, maybe ask for a repair, ask for more information, maybe getting an extension, maybe terminating the transaction, right? If the seller's being that cagey and not providing the information. And here's the problem, that it was never fixed, it was never disclosed. The buyer later claims they relied on your representation, right? And the lesson is it wasn't documented through escrow, there was no signed addenda, there was nothing in writing that ever happened. And except for that text message, which makes look like you were guaranteeing that, the seller will definitely fix that, right? Um, so don't make those guarantees. Email management. I like emails a heck of a lot better than text messages. I know everyone likes text messages, but confirming things in writing, text messages are a terrible format for that. So I strongly encourage people to get out the keyboard and actually confirm things in writing. And here's an example. Again, this is part of another class, or it can be part of another class, but I think it goes with the contract because your contract doesn't end when you sign that RPA. I think it continues on throughout the transaction as issues come up. And part of that is confirming things in email to your client, whether on the buy side or the sell side, but particularly on the buy side, because the buy side is the one who is doing all their investigations. Well, as we hit here 5 minutes after our allotted time, I'm just going to give you kind of my top 10 again, as kind of a final takeaway, and then I'll throw in some questions here, of any questions that you have. I'll take a look at the chat if there's any questions there, or certainly open it up to anything you have. And I'll just throw these down here so that you can get this is kind of an overview. We talked about a number of these issues, but missing deadlines, the poor drafting of those things like the counteroffers or repair requests, not reading the full contract, not being familiar with the contract. I would study the contract, particularly the RPA and those key forms that I talked about. Do it on your downtime. Um, be comfortable. If you don't understand what a clause means, ask for help on that. Ignoring disclosure concerns, incomplete counteroffers, giving legal advice, failing to document communications. These are all things we've talked about, but these are the top 10 that I see in terms of agent mistakes in the contract itself. And here's, what I think good realtors do is they read carefully, they write carefully, or clearly, I should say. That full statement that we looked at, not just lender to fix or buyer to fix, or I'm sorry, seller to fix the roof. They counter aggressively, so they're not just countering when the deadline is, but they're calendaring before the deadline so that they're ready with that notice to perform, or they're making sure that they're aware that something's going to happen. Not at 5 o'clock on that day, but actually the day before. So they're preparing for it. They're documenting everything. They're staying within their lane. They're not going outside of the contract. They're not making it up as they go along. They're using attorneys proactively. right? When the seller or buyer or seller has an issue, they're referring them to counsel saying, that's not something we do. We don't opine about these easements and whether they're legally effective. We're not opining about um, something to that or what your remedies are if they end up breaching this contract. Um, Good realtors also use checklists, right? But they don't over rely on their TC. Your TC can be your best friend in a transaction, but don't pass the transaction off to the TC. Uh, Good realtors also ask for help from their broker, and they're not afraid to do that. I strongly encourage you to do that and attend as many classes as you possibly can so that you're better than your broker at these forums, because this is how you get paid. This is how you perform on a transaction. This is how you get new clients, right? Good referrals come from clean transactions. They don't come from a lot of disputes. I think it's pretty rare when someone has a dispute in the transaction that they refer you to other people, right? In fact, they'll opposite. They'll say, stay away from Fred the agent because guess what he did in my transaction. Um, and so uh, having clean contracts, clean transactions should be your goal from now until the end of your career. And that, everyone, is the presentation for today. I hope this helped. Certainly, if you have questions, I'm available now. But here is my information. I'm told that this barcode goes to my website. Hopefully, it does. Someone told me that on our marketing side. But if you can't scan that, there's my uh, there's the URL, whiteandbright.com, my phone number, my email address. I'm always happy to engage with agents, brokers. And like I said, I do these presentations for North County, for other associations, and certainly for real estate offices, um, uh, and particularly ones that are my clients. And so happy to answer anything you guys have. Is I'm going to check the chat. Um, is everyone unmuted? I don't know if I can do that from here. Shirley, can you unmute everyone?
I can unmute everyone and then they can raise their hand
So it looks like
and unmute themselves.
there's a question from Bob about how do you handle a client who signed the contract, has buyer's remorse, and wants to stop the transaction? Um, I assume that's on the buy side, but it could apply to the sell side as well. Certainly on the sell side, um, I'll just address that really quickly. There's very limited opportunity to get out of a transaction on the sell side. People don't necessarily understand that because sometimes they're used to the buy side where you have these contingencies. Um, but on the sell side, it's very limited. I won't go into detail on that because it seems like the question's about the buy side. On the buy side, if they have buyer's remorse and they want to stop the transaction, I mean, the most effective way is to not release the contingencies, to have a reason, an objective reason to try to terminate the transaction on the buy side. The problems I see on that is poor communication by the agent. Oftentimes there's a dispute over that. And let me give you an example. An example is, it might have been a case of buyer's remorse, but they released a number of their contingencies, and the only remaining and the only remaining contingency in that case was the loan, and the buyer didn't want to buy anymore, not because they couldn't get a loan, but because they just didn't want the property anymore. They had found something else, and they had changed their circumstances. And instead of blaming it on the loan, the agent communicated, well, they had changes in their circumstances in their life, and they're really sorry, but they want to terminate the transaction, and didn't tie it to the actual contingency. And what did the seller do? The seller said, I'm not accepting this. I'm disputing this. I'm not going to release your money. because people are under the impression, or a lot of agents are under the impression, and even buyers, that it automatically terminates. That when you terminate a transaction, you automatically get your money back, which isn't necessarily the case. And so I do a whole presentation on that, but making sure that you're very clear on what your how you cancel the transaction is important, and tying it to an actual contingency. The best one to me is the inspection contingency, because the inspection contingency to some extent is subjective, that the quality of the home is not what they thought it was going to be. And that is, I think, very subjective and much more defensible than if it's tied to a specific contingency that is different from that. And so just communication, I think, is the most important thing. Um, let's see. Someone wrote, I would make part of the looks like Julie answered the question the same way. I would make it part of the inspection contingency unless it's right away after acceptance. Yes, I mean, it's the inspection contingency is normally your best one. So thank you for answering that question. Hopefully my answer added to it a little bit. Um, and let's see. I don't think there's any other. Oh, it looks like you said it was the sell side. So so Bob said it was on the sell side. Um, your question. So on the sell side, it's a little bit more complicated as to whether you can terminate the transaction. There's kind of limited opportunity to do so, and really the best way to do it may be to it's very highly dependent on the transaction, so I don't want to give kind of a broad answer. But one of the better ways to do it is being very tight on, the notices to perform. That I think is key to making sure that the buyer, because if the buyer doesn't perform, then making sure that you can effectively terminate the transaction. It may also be a conversation with the buyer. I've encountered that a number of times where the buyer thinks they're getting a great deal. Maybe it was priced under market. Seller doesn't want to sell, and the buyer starts to enforce it. And it's very heavily dependent on the transaction. So I don't want to give a broad answer, but that's the type of thing where I would encourage you to be going to your broker and probably talking to legal counsel to see if there is an angle, because they're very limited. And that's why the seller should be, really have a really hard conversation with the seller that they may not be able to get, before they start listing that property. Do you really want to sell? Because once we accept an offer, we're not going to have, it's not like the buyer side where they have these broad contingencies. Seller has very limited contingencies, and they need to know that up front. And so, sorry that you're encountering that, but that's a prime example of a case where you're probably going to legal counsel, because the consequences of not effectively if they try to just get out of the transaction, or they don't cooperate, or they fail to sign documents that they're required to sign, can expose them to damages. It can expose them to a specific performance, which is essentially a forced sale of the property. It can expose them to attorney's fees and costs. There's some big consequences there. So that's absolutely the type of issue that I would encourage immediately talking to your broker and probably getting legal counsel involved as well. Any other questions? I don't think I see any more in the chat, but if anyone has any verbal questions, happy to see if I can answer them. Hopefully I can answer them. Looks like everyone's muted. So if that's all, then I thank you guys for attending. I understand this will be up on the North County's website. And again, hopefully you took down my contact information. Happy to talk to you at your convenience. And thank you everyone for attending this morning.